Hello and welcome to the big picture. In an unprecedented move, the Supreme Court directed the centre to revoke the president's rule in Uttarakhand after Chief Minister Harish Rawat managed to prove the majority support in the Uttarakhand Assembly yesterday. The entire Uttarakhand episode, starting from some Congress rebels deserting Rawat till yesterday, when the 9 rebels were kept out of the assembly after being disqualified, and now for the restoration of the government, has raised several issues. These issues, political, legal and constitutional, will have far-reaching effects when similar situations are faced by the governments and political parties in the future. What are the lessons from Uttarakhand? We will discuss this today with Marwah, former governor, PDT Achary, former Secretary General of the Lok Sabha, Sanjay Hegde, senior advocate in the Supreme Court, and Bharat Bhushan, editor Catch News. Welcome to all of you. Mr. Marwah, when this whole episode started, with the rebels, which is not a very unusual thing. We have seen rebels from various parties coming out of but the way the whole episode turned out to be, and what do you think of as a former governor? Do you think that the whole situation was handled correctly?
No, from every point of view, it was a mishandled situation. Politically, I think the ruling party at the centre has committed a self-goal. It was Congress party which was in trouble. They should have let them handle their thing. They interfered and look what has happened. Constitutionally, it was untenable because it is a total misuse of Article 356. The governor, unfortunately, I'm sorry to say, has also not come out very well, because governor, according to the constitution, is part of the house. He could have resolved the technical issues by taking a more proactive role, which he didn't do. Instead, he recommended president's rule. That means it's a failure of the constitution machinery, without giving an opportunity to the House to resolve its technical problem and support the democratic parliamentary process.
Mr. Achary, how do you look at this?
Actually, there are two issues which I would like to raise. One is constitutional, the other is procedural. This president's rule has been imposed on the ground that the Uttarakhand Assembly could not pass the appropriation bill. When the appropriation bill could not be passed, naturally the government cannot carry on because they can't withdraw money from the Consolidated Fund of India.
Right.
So that was the basic ground on which this president's rule was imposed. This was explained by the finance minister and many other spokesmen of the ruling party. Now, I would just, if you give me some time, I would just deal with that particular issue. This appropriation bill comes after the House passes the grants.
Right.
Appropriation bill is different from other bills in the sense appropriation bill cannot be amended by the House. Therefore, appropriation bill cannot be rejected by the House. In all assemblies and in Parliament, appropriation bills are passed by voice vote because division is never permitted.
Is not permitted?
Permitted means it is not permitted by convention. It is not permitted.
Okay.
But I would say.
Is it constitutionally not allowed?
I'm just explaining that.
Okay.
There is a specific provision in the Constitution which says that you cannot amend appropriation bill.
Right.
The reason is the appropriation bill contains the grants which the House has passed. So after the House has passed the grants, the same House cannot reject the bill. Appropriation bill is only to enable the government to withdraw money which has been passed by the House from the Consolidated Fund of India.
So are you trying to say it's a formality?
Yeah, I am saying that appropriation bill, the passing of the grants and the appropriation bill are parts of the same transaction. You cannot pass the grants and after that you cannot reject the appropriation. You can pass the grants, but after that you cannot reject the appropriation bill. That is the point. The implication of this particular provision in the Constitution which says that no amendment is possible is that you cannot, after passing the grants, you cannot reject the appropriation bill. Therefore, I would say that the demand for a division on the appropriation bill was not in accordance with the constitution and the practices. So that was not a very correct, permissible demand. And from that point of view, what I would say is that the decision of the Speaker of Uttarakhand Assembly to pass this appropriation bill by voice vote is the right decision. He could not have done otherwise.
He couldn't have done anything else.
He couldn't have done otherwise.
Okay, that's very interesting what you said. Do we have Sanjay Hegde? Sanjay, can you hear me? Yes, Sanjay.
Yes, I can hear you.
You know, Sanjay, Mr. Achary has brought out a very, very interesting aspect to this whole thing. Now that, of course, the government has been restored and Harish Rawat will come back as Chief Minister. But we have to deal with certain issues which have come up. One of the issues which Mr. Achary is talking about. The other issue is about how the High Court as well as the Supreme Court have conducted themselves in this whole issue. How would you look at it?
See, the doctrine was laid down way back in Bommai's case. Bommai's case is now nearly 20 years old.
Right.
But the actual application in a live situation has happened here. What used to happen was that almost invariably central governments would impose president's rule and then try to justify it in court long after the events had become stale. You'll remember the Bihar situation where the assembly was not even convened, and despite that, president's rule was imposed and the assembly was sought to be dissolved. The Supreme Court said that the imposition of president's rule was wrong, but then they did not revive the assembly simply because fresh elections were due. This used to be the fact situation each time. Therefore, even if the courts continually said that the invocation of president's rule was wrong, there were no real consequences. And somewhere the center seemed to get an attitude that, okay, we'll impose it, we'll defend it in courts, and we'll see to it when judgment comes. But anyway, the judgment will come in God's good time, and it need not really bother us. Here is the first instance where the doctrine of Bommai got teeth, and those teeth were applied in a live situation.
Right.
In future, I think the government at the center will be wary of routinely imposing president's rule. They will probably have to check it twice or thrice with their legal team to ensure that there are no hiccups or that a court cannot find fault with the procedure. In this particular case, a vote of confidence was scheduled to be had the next day. That would have resolved everything in accordance with Bommai. But in an inexplicable hurry, the center recommended president's rule and the president signed on the dotted line. So a lot of authorities have not exactly come up smelling of roses. At any stage, if the right questions were asked, if it had been examined, is it in accordance with Bommai? Is it in accordance with Rameshwar Prasad? Is there no alternative to imposing president's rule? If these questions had been asked, I venture to say that maybe this misadventure would not have happened.
Okay, this is a misadventure. According to you, this is a misadventure, and I'll come to the aspect of how the High Court and the Supreme Court, in specific instances in this last 1 month, how they dealt with these issues. But before that, Bharat, what is the political implications of this?
Political implication is a big slap in the face of the central government. It's a slap in the face of all those legal luminaries who are writing blogs and saying that it appears to us sitting in Delhi that the appropriations bill was not passed, knowing fully well the Speaker is the master of the House. If it appears to him that it's been passed by a voice vote, as Mr. Achary has amply explained, then the bill had been passed. To say that there was a failure of the constitutional machinery, that had not been demonstrated. It wasn't as if there was a hung assembly. It wasn't as if there was any group which was unable to form a government. There was a functioning government. It wasn't as if there was insurgency in the state and therefore the government couldn't function. So there was no failure of the constitutional machinery. It's just that the BJP, in its hurry to grab power, was misled by Congress rebels led by Vijay Bahuguna, and they thought here was an opportunity to form a government. I think this kind of impatience has its own price, and they're paying that price because 8 months later there was going to be an election. Who knows, they would have won. But where was the hurry? Where was the hurry for this kind of political cunning to bring down a duly elected government and impose some kind of BJP rule?
No, Bharat, the question here is, here were these nine rebels of the Congress party who have approached, who approached the governor, who approached the... What do you expect the centre to do in these kind of situations?
Use the Bombay judgment. Let the floor test take place. Because they knew that even if the floor test happened, as has been demonstrated amply yesterday, with the help of independents and a nominated member, Harish Rawat's government would have continued. So I think it was exceptionally foolhardy on part of the BJP to sort of embark on this misadventure.
Mr. Achary, actually, let us assume that these 9 rebels were not disqualified, and the original date on which the vote of confidence was supposed to have taken place, before which the president's rule was imposed. On that day, if the president's rule had not been imposed, the vote of confidence had taken place, and the rebels would have remained members of the House, and they would have voted.
You see, if they had voted against the whip of the party, then they would have incurred disqualification.
But what would have happened to the government?
Yes, certainly. Disqualification comes after the voting.
Right.
And the voting has a certain consequences. So the government may fall if they vote
Could have-
against the
could have
government.
fallen.
If they vote against the government.
Yes.
After that, they will face the consequences. But then, once the government has fallen, then so many other developments will take place.
Right.
And we can't say what will happen or what would have happened after that. That is true.
So
So
waiting for the original floor test to have taken place would have been the best option available, actually.
actually, I do not want to discuss politics such. But the point is that one day before the floor test, this president's rule was imposed. And that is why all these other complications, took place. In fact, president's rule is an option only after the floor test. Suppose the government loses majority in the House, and there is no possibility of any other government being formed. In that case, president's rule is the option.
Right.
But that option will arise only after the floor test, not before that. Because it is actually ridiculous to impose the president's rule just a day before the floor test was to be held. That is
Mr. Marwah, what are the lessons for the government from this, according to you? For any government in future?
Well, it's unfortunate that these lessons are not being learned. As has been said, the Bombay case took the judgment was 20 years ago. So, politically, the way our politics are being played, I am not very sanguine that this sort of thing will not happen again. But they should also know what the consequences are. Apart from the constitutional misuse of Article 356, it is political price which will prevent them. And I entirely agree with Mr. Bharat Bhushan that the ruling party at the centre is going to pay a heavy political price in the forthcoming Uttarakhand elections for this folly.
Okay, Sanjay Hegde, the question is, the Supreme Court, the role of the Supreme Court, High Court, the High Court, first said that in fact, the High Court went ahead and revoked the President's rule, which the Supreme Court stayed, and then Supreme Court ordered a certain way in which the floor test has to be conducted. How do you look at that order of the Supreme Court?
You have to look at things in sequence.
Yes.
What happened was that the 9 MLAs first got disqualified.
Right.
Then there was to be a floor test. Before the floor test, the president's rule was invoked. That was challenged. Before the High Court gave its verdict, the High Court specifically asked the government, please, can you give us an assurance that you will not revoke president's rule and try to form an alternative government?
Right.
The central government lawyers at that point of time did not give that assurance. The High Court wanted that assurance, particularly to be sure that in the period that it took to write its judgment, that no alternative events occurred which would render the whole matter infructuous.
Right.
When such an assurance was not given, the High Court then passed its order. It passed the operative portion of the order, striking down President's rule, and then it was dictating its order. Immediately, the centre came to the Supreme Court. So the Supreme Court was faced with a situation where it did not have the complete judgment. It had only the operative part.
Right.
So the Supreme Court said, okay, let's maintain status quo for the moment, because in the meanwhile, the Chief Minister, on the basis of what the High Court's operative order, wanted to get back into office.
Right.
So all in all, the courts were more or less in an exercise trying to restore the status quo. These courts also had to balance the various provisions of the Constitution, including the provisions of respecting the proceedings within the House.
That is exactly the point.
When the matter finally came to the Supreme Court and the hearing was on, when the Supreme Court suggested a floor test to be finally held, it had to make certain arrangements, particularly because the President's rule had been invoked, and there was a stay of the Supreme Court keeping it in place. So there was a delicate orchestration where the Supreme Court varied its order for a day, allowed the President's rule to be revoked for the time that the Assembly held the floor test, and then thereafter again it was imposed. And today morning, the Supreme Court was told by the Attorney General that because there was the order which prevented them from revoking President's rule, they had not revoked. They sought the leave of the Supreme Court to revoke President's rule immediately, consequent to the floor test. I must compliment the government for not having precipitated the matter further after the floor test. Conceivably, a more hard-headed government might have taken up further constitutional questions of ambiguity as to, by insisting that the entire matter on the validity of the President's rule be heard in full before the government could be back in office.
Okay.
Thankfully, the central government has not done that. The President's rule will be revoked according to the assurance given to the Supreme Court, and Mr. Rawat will be back in office.
Okay.
This unhappy episode needs to be put behind us, but all the legal questions and constitutional questions which have arisen during this episode still require a definitive answer so that they may serve as guidance in the future.
Okay, that's interesting, Mr. Achary. Mr. Achary, this whole episode about, especially the last portion where the Supreme Court said that this is how the test needs to be conducted. We have been through these situations earlier.
We have been through this situation earlier, and the then Speaker, Mr. Somnath Chatterjee,
Right.
Had very vigorously protested against it.
Right.
He, in fact, held an emergency meeting of all the speakers of various assemblies and said this is not the function of the court. The court is interfering in the functioning of the legislature. In fact, our constitution provides for separation of powers, and the legislature is supreme in its own sphere. It is the function of the legislature to formulate procedures, lay down procedure for the conduct of its business. And the court has no role in that. So that was the position taken at that time. In fact, this is almost a repetition of what happened in the Jharkhand case. I would say, of course, I am of the view that the floor test was necessary. In fact, Mr. Harish Rawat was deprived of an opportunity to prove his majority in the first instance, and that was allowed, and he was allowed to prove his majority. That is good so far as it goes. But then the point is that the procedure that has been followed, or procedure that has been laid down by the Supreme Court in this particular case, will have far-reaching consequences. There may be conflicts between the judiciary and the legislature in future. First of all, Supreme Court fixing the date of the assembly, and Supreme Court lifting the President's rule temporarily
for 2
hours. And then the question was, by lifting the President's rule for 2 hours, are you reviving a government which had gone out of office? Because, you know, the confidence vote is always in the Council of Ministers. A chief minister comes on behalf of the government, moves the motion and seeks the confidence of the House in the Council of Ministers.
That's right.
Because
It's not
not an
individual.
individual. Council of Ministers is collectively responsible to the House. That is why the confidence is always sought for the Council of Ministers, in the Council of Ministers. Here I do not know what actually happened. I am not very fully aware of the motion that was placed before the House. Then lifting the President's rule, I will just take
One more point which I want you to address. The Supreme Court directing the Speaker how to conduct the floor test.
Yeah, that's what I was coming to that. So that itself, you know, Speaker is supreme so far as the legislature is concerned. Because the rules of procedure framed by the House puts enormous powers in the hands of the Speaker to conduct the proceedings of the House. No other authority can step into that area.
Right.
Because, you know that Constitution provides absolute immunity to the proceedings of the House. I mean, it cannot be challenged on the ground of procedural irregularities.
Right.
So that kind of immunity is available to the House. That being so, Supreme Court directing the Speaker to conduct the proceedings in a particular way, that the members will sit, the members in favor of the in favor of the government, Mr. Harish Rawat will sit on one side, and the others will sit on the other side, and there will be an observer who will be observing these things. These are alien to the established procedure of the Houses. So,
has that immunity been?
In fact, I won't say that immunity has been breached or anything, because the proceedings have not been challenged. So that question doesn't arise there. But the point is, the Supreme Court has laid down a procedure which is totally at variance with the established procedures of the Houses. That is where the problem comes in.
That's where the problem will come in future also.
In future also.
Mr. Marwah, you would like to?
You know, one wrong leads to another wrong.
Yes.
And it is important to realize that under the Constitution, there is no provision for obtaining a vote of confidence. There is a provision for a no confidence motion, but not obtaining a vote of confidence. So the Rawat government will be in power unless defeated on the floor of the House. So the floor test was the only answer to the situation.
Sanjay, how do you respond to this? What Mr. Achary is saying as far as the procedures are concerned, and has the immunity of the legislature been breached to some extent here?
Absolutely.
Yeah, please.
You see, our parliament and our legislatures owe a lot to the English practice and the English parliament. But in England, parliament is supreme. In India, the constitution is supreme. And the interpreter of the constitution is the Supreme Court. Now, the Supreme Court was invoked by members of the legislature, and it had to come out with a solution. Because, see, the difference between England and India is that India now has the anti-defection law as part of its constitution.
Right.
In that, the speaker is the deciding authority. When the speaker decides, he becomes a tribunal.
Right.
So we have a kind of mixed procedure where the speaker has more than one hat, and consequently, when to set right certain things which go wrong when he's which possibly could have gone wrong or which were challenged in his role as a tribunal, the Supreme Court then has to come in and devise a hybrid procedure. Even I was among those who was rather surprised in the 90s when the Supreme Court first devised this procedure between Kalyan Singh and Jagdambika Pal. But now it looks that this is the third time that such a thing has happened. And I do not know how many more times in the future it will happen. Ultimately, all that the Supreme Court has done is to become a third empire, to review everything and to ensure that if a batsman has to be declared out, he has to be declared out in accordance with the rules of the game.
Yes, Mr.
Jagdambika Pal's case, the Supreme Court had devised this kind of procedure for the first time. At that time, they had made it very clear that this is not going to be a precedent for future. It was made very clear
was
by
made
the Supreme
clear,
Court.
that's
because
right.
They were quite aware
Yes.
of the fact
No,
that this
that
was
is, that
a
is why
variance.
that's why the Supreme Court did not
Yeah, this
have
was-
the same kind of.
They were quite aware of the fact that this was actually the procedure that they devised was at variance with the established procedures of the House.
Right, but as far as the immunity of the House is concerned, in the way it conducts the itself, the way the Speaker will conduct the House, there seems to be a problem there.
Yes, there is a problem.
Bharat, in the light of all these things, do you expect political parties to take these issues beyond what has happened now to get some clarity, or you think that the political parties are now happy with dealing with whatever the situation? Congress will be quite happy, getting the government back in power.
I think they would be happy to limit the damage they've done to themselves. In this process, not only the BJP has been damaged, but Congress has also been damaged.
Absolutely.
And Congress's own mismanagement has come to the fore.
Right.
For example, why were the rebels not managed properly beforehand?
Exactly.
All you had to do was accommodate Vijay Bahuguna, former Chief Minister. You sacked him, but he could have been accommodated in Delhi in Rajya Sabha. You chose to bring Raj Babbar, who lost by a record margin in Meerut from Uttarakhand, as if he's a great parliamentarian, and one would like to know what has been his contribution to parliamentary procedure since then. So what I'm saying is, parties behave in odd fashion, and when this kind of damage happens, they tend to limit it. But I think what the panelists are saying is that there are some fundamental questions which have been raised by this crisis, which remain unresolved.
And that remains to be resolved. Sir, just one more point before we have to end very quickly. The Supreme Court has kept it open for the Speaker to deal with as far as the rebels are concerned. They're saying that, the Speaker can review his order. You think that can happen?
Speaker cannot. Speaker won't review his order. Speaker is a tribunal. He has given his order, and it is for the parties to approach the court, and they have done it. It has actually come before the Supreme Court now. And there the Supreme Court will decide this case on its merit. In fact, I would say that these 9 rebels, they have joined hands with the BJP. They went to the governor, signed a joint memorandum.
And that is voluntarily giving up the membership.
I'm saying that. So that amounts to voluntarily giving up the membership of the party. Now, that is a very solid ground. It is an open and shut case, as they say, because a similar case was decided by the Supreme Court. Yeah, a similar case was decided by the Supreme Court in 2007 in the Rajendra Singh Rana's case. It's a very important case. And there the Supreme Court has said, if a ruling party member, along with the opposition, approaches the governor and says that the government of which he is a part should be dismissed, you don't have to look further. That is a sure case of a member having voluntarily given up the membership of his party.
Okay. I think on that note we need to end. But then there's still very important constitutional and legal questions which needs to be discussed, debated in this. We hope that the more debates will take place, more clarity will come out of it, and in future governments will not face these kind of situations which they have faced, and the role of the courts in these situations are also something which needs to be discussed further. Thanks to all my guests. Please keep watching. We'll come back with another issue in the big picture same time tomorrow.